self-introduction. My name is Martha Komya. I'm the chairperson of the JSC. Welcome for this interview.
Thank you, Chief Justice.
Good afternoon, Your Honor. Jacqueline Ngutia, Commissioner.
Good afternoon, Mheshimiwa. Nzilani Caroline, karibu.
Thank you, Commissioner.
Good afternoon, Mheshimiwa. My name is Charity Kisoto. Welcome.
Thank you, Commissioner.
Good afternoon, Your Honor. Anthony Mrima, Commissioner, welcome.
Thank you, Commissioner Judge.
Good afternoon, Jokindongo.
Thank you, Judge.
Good afternoon, Honorable Barasa.
Thank you.
My name is Fatuma Sichale. Karibu sana.
Thank you, Judge, Commissioner.
Good afternoon, Mheshimiwa.
Good afternoon.
You're welcome. My name is Oluwande Evelyn.
Thank you, Commissioner Chief.
Good afternoon.
Good afternoon.
Dr. Sodwar, Senior Counsel and Attorney General.
Thank you, Commissioner. Thank you.
Yes, we can start, Mheshimiwa, by you telling us your county and your ethnicity.
My county is Kakamega and ethnicity is Luya.
Yes, we will now start the interview, which is a form of a conversation with you. First of all, we have read your CV and your papers and the sample writings you sent us, but we want to hear it from your own mouth, who you are, what you have accomplished in terms of professional achievements, experience, knowledge, that makes you think that you are the most suitable candidate or you are suitable for this position of a judge. We also want to hear your vision. What vision do you have for this position of a judge of the High Court? You have 5 minutes.
Thank you, Chief Justice. My name is Harrison Barasa, Omwima. I'm a Chief Magistrate, currently serving as the head of the Anti-Corruption Milimani Court, Nairobi, as the head of station. I've been a judicial officer since 2007. My first station was Nakuru. I've served in many stations across this country, including places where we have the marginalized communities. I've served in Turkana. I served there until 2013. From there, I went to Kapenguria. From Kapenguria, I served in Eldoret, engineer, and then anti-corruption. You've asked me to tell you my achievements. The achievements are many. I don't know if the 5 minutes will be enough for me, but I'll try. In the course of my service in the judiciary, I think I know I've really contributed to the development of the law in this country. I've also contributed a lot towards, the progression of the institution. In Turkana, I dealt a lot. That was even before devolution. I dealt a lot with, matters that had to do with marginalized communities. That is in Turkana and also Kapenguria. In engineer, there is where I think that was my favorite station, and I say this because that is where I came up with an innovation that really spoke to Sturge, the current blueprint in the judiciary, and that really enhanced access to justice to the vulnerable community. That is a priority card, priority stroke express card. Basically, these are a simple innovation, a very simple innovation that did not require any financial input because it just required the intention of, that is myself and my team. Maybe if you may allow me, I can expound more on that innovation, with your permission, Chief Justice.
Know about the priority card, if you can go to another achievement.
Yes, the priority card, there's a paper that I've written. I think it is attached as part of my CV. So in terms of that is backlog clearance, I've really, as an individual, and also working with other members of the judiciary, I've also played a very huge role in ensuring that backlog is reduced. When I was in Eldoret, I think we came up with many initiatives that went towards backlog reduction. And also there's the issue of corruption and integrity. I think I can say, because even the issues integrity and fighting corruption also depends on individual energy. And I think I've been able to achieve that because in Engineer, I think it is one of the stations which had a zero perception index, almost in twice, that is in 2 consecutive years. And I believe that is what maybe contributed to my being brought to anti-corruption court. It is not easy because you have to you come up with the simple strategies again, and that my experience is that corruption is something that you just need to talk about it. You talk about it, I think you've done a lot towards eradicating that corruption through our morning briefs and what have you. And that is a practice that I've also brought to anti-corruption court, and it is bearing fruits. In fact, I must say it is something that, I've brought almost everybody on board. And we know at anti-corruption court, it is a zero tolerance, a zero corruption tolerance area. And also, I've also come up with innovations at anti-corruption court. And it is an innovation that we've given a name. That is time tracking card. When I came to anti-corruption, that is from Engineer, I was used to churning judgments, many judgments. When I came to anti-corruption court, I found that colleagues were just churning 2 judgments, 3 judgments, 4 judgments. And I started asking them, what is this? What is it? Of course, they would say that, these are complex matters. So we sat down as a team and we came up with a card because we wanted to really track down these cases. We wanted to really, wanted the card to speak for the file. And these are cards where we would record, of course the court assistant would record every activity in the courtroom. Right from when the magistrate walks in, the hearing, he'll indicate the time taken by, let's say, a witness. If there's an objection, because in corruption cases, you'll find that there are objections after objections. At times, the objections are done just to ensure that maybe you give them an adjournment. But then, of course, with that, we dealt with that because we give rulings almost there and then. So even if the magistrate retreats back to chambers, that one is noted, so that even the 1 hour or 1.5 hours that the magistrate is in chambers doing his ruling, it is also accounted for, and it is written in that card. So that at the end of the day, we have the total number of hours that case has taken, so that anybody picking that file can quickly just go to the card and he'll be able to see that this file took these judicial officers this number of hours. So that you cannot accuse him or her of not having worked. Because as compared to other courts, you would find that maybe he took...
Okay, thank you.
Yes.
I think some of the feedback you're giving will be asked by Commissioner Olwande.
Thank you,
The next set of
Commissioner.
questions will be asked by Judge Murima.
Thank you.
Thank you, Acting Chair, and welcome.
Thank you,
once again,
Commissioner.
Mheshimiwa. Now, with the birth of the 2010 Constitution, many things happened in judiciary, including the coming up of the three superior courts, that is the High Court and the two courts of equal status. And in terms of their jurisdictions, it was not an easy sailing. There were lots of conflicts and jurisdictional issues. Are you able to point out at least two aspects on jurisdiction, how they played out, and whether they have now been reconciled by maybe the Court of Appeal or maybe the Supreme Court?
First, I would, one of the conflicts was related to the jurisdiction, that is between the courts of equal status and the High Court. Courts of equal status, the High Court and the High Court. Because maybe what comes to mind is the case of the Karisa case, where the ELC judges, I know it was in the course of the administration. Of course, they wanted to reduce backlog and what have you, where they dealt with a matter, a criminal matter, and then the matter went up to the Supreme Court, and the Supreme Court resolved that the judges of equal status are not supposed to hear criminal matters. That is an exclusive jurisdiction for the High Court. Yeah.
Okay, that's one area. Maybe another area on jurisdiction, which may have been settled by now.
I think, Commissioner, that is the one that I can remember. Okay. That is very clear in my mind.
Okay.
Yes.
In the issue of mixed grilled cases, the Court of Appeal has come up with a test, predominant issue.
In fact,
it's very important, Mheshimiwa, you should go and rehearse properly on that, because those are the things you'll be handling every day when you cross talk.
Thank you, Commissioner. In fact, that question has refreshed my mind.
Yes.
Yeah. There's also the issue of that is a concurrent jurisdiction, where there are matters which fall in between. Some of those matters may have some aspect to land and some aspect to, let's say, normal transactions. So, and I think that is where now the predominant, issues came up in terms of determining which. So that one has also, I'm not sure if it has been resolved fully, because the ones I remember for, I think the views of two judges. I think one is Honorable Justice Ngugi and Honorable Sila Munyao. They took different views on that, but I think the outcome is the same. So you look at the matter, if it is predominantly a land matter, then it goes to ELC matter. If it is predominantly a matter that can go to the High Court, then the High Court deals with it. And I remember Justice Ngugi gave an example of where maybe a matter, there's maybe a transaction relating to land, and maybe there's in the same matter, there's a transaction to do with the construction. So you look at the matter, if you see now the construction aspect, transaction is larger, it's more predominant than the other aspect, then the High Court deals with it. Okay. If not, it is transferred to the ELC court.
It's okay. Now, some bit of a criminal practice and a scenario comes in. A matter is tried in the magistracy. It's a criminal case tried in the magistracy, and the accused is convicted. Goes to the High Court on first appeal, loses, goes to the Court of Appeal on second last, and loses again. This person comes back to the High Court and files a petition for a retrial. The petition is dismissed. Comes back to the High Court, files an application for revision of sentence. The revision application is dismissed. These are things which you will encounter every day if you come to the High Court. It will be the order of the day, especially if you land into the criminal division. Then, this person comes back again with an application on the basis of decongestion. Says, I need to be released in the interest of decongesting prisons. Do you think that application is likely to be hinged on a certain provision of the law? Or it's a policy issue also?
Now, when he finally, I think I'll take it that after going to all those courts, for him to be coming back to the High Court, maybe pleading that he benefits from the decongestion process, I think he'll have given up on all the other processes. And I don't think it is, I think there's a policy issue because as a judiciary from time to time, we do decongestion exercises across the courts. So we look at the matter. If he deserves, I think I'll grant him the request.
Yeah, so I mean, on what basis? Which law allows you? Because you see, as a court, you only operate within, you are like a caged animal. You operate, but within the law. Which is this law which allows you to even do that decongestion?
Because under decongestion, we normally do them under the community service orders. Yes. So if he meets the threshold, I think it is fair, he'll benefit.
Okay.
Yes.
Okay, thank you. Mheshimiwa, I wish you the very best.
Thank you.
Yes, good afternoon. Sir.
Good afternoon, Commissioner.
Now, are you able to tell me the workload that you have in your court? How many cases are pending?
Yeah, for now, I can say anti-corruption is a very unique...
Your court?
Yes, mine.
Yes. How many cases are pending?
Honorable Barasa's court.
Yes.
Oh, I think I have 18 main cases, and for his applications, we have ex parte applications. Ex parte applications as I think as at around last week, it was around 220 or thereabout.
Between July 2025 and January 2026, how many judgments have you written?
Between?
July 2025 to date, from the beginning of this financial year, how many judgments have you written?
I'll put it at 3 to 4.
My information, because I asked for this information,
yes.
My information is that between 2025 to 2026 to date, only one judgment has been written.
To today?
Yes.
2025?
Case events 762, ruling not concluding a case 246, ruling concluding a case nil, judgment delivered 1, on merit 1, cases closed by other means 209, making 210, which means it is only one case that has gone through the entire prosecution system and resolved.
Oh, sorry, I think I'm confusing with the one that I delivered in June. I think
But is that correct?
There are two. I've delivered 2 judgments.
My information is 1, so it is 2.
It is 2.
So for the last 7
because
months...
Because even before coming here, I delivered 1. Was it last week?
So do I take it that for the last 6 months or for the last 7 months, you've only written 1 judgment?
I would say yes.
So what is your backlog clearance rate?
As an individual?
As an individual, having written 1 judgment in 7 months.
I think for the 7 months it is two judgments, Commissioner.
Even if it is 2.
Yes.
Backlog clearance.
Okay, maybe I'd explain it this way. At anti-corruption, during setting of targets, we set for four judgments.
I'm just concentrating on you so that we move forward. So do we then agree that in the last 7 months, according to my record, you've written 1 judgment, but you're saying it is 2? And I'm just wondering at the effort at clearing backlog as a chief magistrate, the head of the court?
Maybe if you allow me, I can explain, Commissioner.
Yes.
Yes. As I'd said earlier, anti-corruption court is a very unique court. When I came in, of course, I got these cases which were ongoing. So you'll find that I dealt with them before the end of that year. So coming to the 2025, 2026, you find now you are left with these cases which are mostly new, fresh, and some of them have just come back from the High Court, some even from the Supreme Court.
Okay, let's move forward.
Yes.
There is a column that says that cases resolved by other means, which makes 209. Which are these other means?
Yes, thank you, Commissioner. The other means we've embraced plea bargaining at anti-corruption court. And believe you me, there are a lot of matters that are being resolved through plea bargaining. They do not necessarily go through the full trial process. And in my court, I think there are many of such matters that have been able to clear within before going to trial. That's why there are no judgments.
After plea bargaining, do you write a judgment?
After plea bargaining, we do sentencing.
And you write something?
Yes.
So would that be other means, or it is in the process of judicial disposition of cases?
I think it is a category as other means.
Other means?
Yes.
So we take it that out of all the 210 cases that have been resolved, 209 have been resolved by other means, only 1 went through full judgment.
Yes.
Trial. Okay.
And then
all right, it's okay.
There was the other aspect, because I've just explained one.
Yes.
We also handle a lot of applications. That is the investigative stage.
No, I was just dealing with the judgments, the ones that have been had fully and resolved.
Yes.
It's okay. So my final question to you is that there is a practice that is developing in the judiciary on something called anticipatory bail. What do you understand by anticipatory bail? And on what conditions would you grant anticipatory bail?
Yeah, anticipatory bail is basically, just as the word suggests, bail in anticipation, whereby, a suspect has information or things that he'll be arrested. Maybe he has heard that there are investigations going on against him. So he would come to court to preempt that arrest by asking for bail as he awaits to be arrested.
So what law underpins the grant of anticipatory bail? Because Article 49 of the Constitution speaks about an accused person who is arrested and brought before court as having a right to bail. If you go to the Criminal Procedure Code, talks about an accused person who is brought before court. If you go to the bail and bond policy, it also talks about an accused person brought before court. Kindly, because we are now discussing, where do we get the legal underpinning for this anticipatory bail? And if it came before you in the High Court, what would you rely on?
Thank you, Commissioner. I would still go to the Constitution. And,
which section?
The same Article 49. And this is how I look at it.
Can I read it to you so that we move forward?
It's okay. I would maybe explain why I would go.
No, I just want to read it so that we move quickly. It says, an arrested person has the right, A, B, C, D, to be brought before a court as soon as reasonably possible, but not later than. And then fair hearing, it goes to let's see, an arrested person to communicate to be compelled to. Okay, that is 49H. So the 49.1 is an arrested person has the right. Then if you go to H, to be released on bond or bail on reasonable conditions pending a charge or trial, unless there are compelling reasons to be released. So we are talking about an arrested person. So then take me back to the Constitution.
Yes, I'll go back to the Constitution, and I'll still, of course, refer to that particular article. But again, if you look at the Constitution, you'll find that the Constitution is about protecting rights, and one of which is, human dignity. So, if this person who believes that he is about to be arrested, he has all the reasons to believe that he'll be arrested.
Why do we issue bond? What is the purpose of the bond?
Bond is basically to ensure that this person attends court.
For what purpose?
For trial, even as the trial goes on.
So now let's juxtapose it with a person who has not been arrested, has not been charged. What would be the reason for granting anticipatory bail in the absence of direct constitutional or legislative provisions?
Because I would look at it this way, Commissioner. Interpretation of the Constitution, should be purposive. So, you are giving life to this Constitution. There may not be a direct provision to that. But if you look at Article 49, then if you look at the other rights that are meant to be protected,
those are the ones I'm looking at.
Yes.
Those are the ones I'm looking at. Do you think that there is a need for us to just clean up that area because it's a bit greasy?
I agree with you, Commissioner. But before that,
yes,
there must be a remedy. This person who comes to court, yes, there is no that direct provision, but Article 49 still talks of an arrested person. And then the Constitution itself still talks of other rights, one of which is human dignity.
But why would the remedy just be anticipatory bail or bond? Even if your right is being threatened, why would the remedy for that just be found in issuing of bail or bond, anticipatory bail or bond?
Commissioner, I agree with you. There must be,
and in case where
there must be some legislative.
In cases where they are granted, do we normally find time limits, or are they unlimited?
No, they should not be unlimited, Commissioner. You must cap it. You must give it some timelines and
have
conditions.
you heard of any case where the court has capped the time or given directions that it should not be unlimited?
I've not interacted much with anticipatory bail, but in principle, if I was the one to deal with it, I think
it has come before the anti-corruption court, where we find people who are being charged with very serious corruption cases go to court and get anticipatory bail. In your court, actually, not you. Matters pending before that should be pending before your court. Because I want us to look at the balance between the right of that person and the right of the administration of justice. This is a person who, for example, is supposed to be charged with a very serious criminal offense, and then the person is granted anticipatory bail. So the police cannot charge this person. Where is the balance? I'm not saying it is you. I'm just wondering, because it's also disturbing me. I don't know whether you are clear in your mind that it is provided for and it should be issued in any circumstance.
Thank you, Commissioner. Maybe my mind is just overworking in terms of looking at this Constitution and trying to, because it's I subscribe to the philosophy that the Constitution is a living document.
Okay, finally, let me ask you. Your rights under the Constitution can be limited by provision of law. We have laws that can curtail your freedom, especially where you commit a criminal offense. So even if you run to court that your right to liberty is being threatened, it is being curtailed by a provision of law that has been prescribed.
Yes, yes, Commissioner, I get you. That is why I'm saying if it were me, I would give very stringent conditions. And that will just be a stopgap measure. And it will be basically to prevent maybe another, infringement of a right that this person has come to court because he fears that his rights are about to be infringed.
And you remember,
upon.
you've not had the prosecution or the police. You just have the person before you, expert. So how do we balance?
Yeah,
Sorry. Anyway, maybe for another time.
Thank you, Commissioner.
Thank you.
Sorry, maybe I was also being too hard on you.
No, you are not too hard on me. It is good. It is good conversation. But you can understand where I'm coming from. Because you've been in charge of a very, very serious court. I know your workload is a lot. But in the midst of all that, for example, you've been complaining that cases take too long. But some of the cases take long because of the orders that the accused persons or the would-be arrested person get, isn't it?
Yes, sir. Yeah. And if you, with your permission, Commissioner, that's why that brings me to your question of the one judgment, which I say it's two. If I had spoken about the time tracking card, if you want to know the number of hours that Honorable Barasa spent on that one file, that card is just there. You just need to go to it and you'll see it tracks down how many witnesses, documentation, cross-examination, how long it took up to the end, so that you will not be
I
talking.
agree with you. I was privy to a discussion here before this commission where some judges were saying that judicial officers who deal with corruption cases should not be evaluated the same way other courts are being evaluated. But then it brings to fore the fact that the performance management tool then has to be customized to reflect the realities on the ground.
I agree with you.
Thanks.
Thank you.
Before that, just a clarification, Mheshimiwa. When a court issues an anticipatory bail, does that bail stop the police from continuing with the investigations and formally presenting charges before court? It doesn't?
No, it doesn't.
Thank you.
Thank you, Honorable Chair. Honorable Barasa, I understood it that you having been taken to the anti-corruption court and you are the one in charge of the anti-corruption court. Who was there before you?
Before me, there was Honorable Thomas Nzioki.
All right. So yes. It actually meant that in terms of integrity, your integrity ranks very high.
Yes, Commissioner.
Having not known you, but just the fact that you were taken there. But I think what is troubling me is the fact that in 7 months, you've done one judgment. Okay. So how many witnesses were in that case?
There were several, Commissioner.
How many? How many?
Like that one, it was the one that I delivered, I think in just 2 weeks ago. They were around 6, 7. I'm not wrong. Huh?
Only?
Can I explain, Commissioner? Yes, sir.
So how many
now
hours?
Now there is the issue of documentation. These witnesses, you will find that one witness would testify for almost 2 to 3 weeks. Just trying,
so
the documentation.
Let's say 21 days. Each witness has taken 21 days. Times 6 witnesses. That works out to how many? 21 times 6. 126 days. That's about 3 months.
Yes.
And so in 3 months, you've had one matter continuously. And then another 3 months to write the judgment.
Not continuously, Commissioner. There are other matters that we also
I do appreciate that yes. But the total number of days that you have spent on that matter is about 3 months.
Unless I refer to my tracker, time tracking card, Commissioner, I may
Are
not
you
really.
yourself satisfied with that performance?
Yes, I am satisfied given the nature of the case that I dealt with.
You know now when you come to the High Court, and this is the practical reality, is that even when judges go to attend the colloquium in Mombasa, they carry files with them wherever they go. So I can imagine that for you, for 6 months, you had no file that was pending to write a judgment because you are still hearing the matter.
Now that you've asked, Commissioner, with your permission, because this is a very serious matter, even to me. I had 4 matters, 4 hearings, which had already given time allocations, had already blocked my diaries for several of those matters, including the one that I did the judgment. Then in between, I get a stay from the High Court.
So you have a lot of free days because
So
that stay
this
has
stay,
been, yes.
we had already, because the way we give dates, you find that we block a whole week, another 1 week for all those matters. So you find that you have 2 matters or 3 where you get a stay from the High Court, and therefore now this one confuses even the dates that you had already given.
Yeah, so when the High Court grants an order of stay and you had listed a matter for 3 weeks, that basically means that for the next so many days, you're actually free because your diary doesn't have any other matter. You had listed this particular matter for hearing.
And remember, we're also dealing with the advocates. You find these are matters where there are several accused persons with different advocates.
But the matter has
So
collapsed. The High Court has granted.
It's the other matters which have collapsed. Now you have this one, which you'd already blocked the diaries.
Maybe there is something that we are not getting. Yeah, because for me, I find it like difficult to believe that you can actually make good use of judicial time if in 6 months you're just delivering one judgment. Here we are being told the High Court is looking for heavy lifters. And would you fall under that classification of a heavy lifter?
I will judge because as I had explained earlier, when I came from engineer, I was used to churning several judgments. When I came to anti-corruption court, I found a totally different ballgame, and those were the circumstances that I found. So even as we speak, we are still trying to come up with ways through which we can.
Okay, I know that there are some of your colleagues who will also be coming, I think, from the anti-corruption court. Maybe we can then compare and contrast to see how you're faring on vis-a-vis them. But now, I have one question for you. Section 210 of the Penal Code speaks of an offense called infanticide. Do you know about that offense?
Yes, I know about it, Commissioner.
What is it all about?
In infanticide, there's the killing of an unborn child, a child who is just born.
Which is which? The killing of an unborn child?
No, the killing of a child who has just been born.
What about it?
Yeah.
What about it?
In terms of kindly.
No, I want you to explain to us about infanticide.
Okay, infanticide, this is a scenario where, a mother gives birth to a child, and then maybe one day old, and then for some reasons, maybe in most cases it is attributed to a state of mental state, she strangles or kills that child. That will be infanticide.
So the offense the sentence that offense would attract would be what?
The sentence, I'm not sure about the sentence.
Would it be murder? Would it be murder?
It would not be murder.
What is it?
It would be treated like manslaughter.
Yes, it would be treated like manslaughter, but the time frame within which this must occur for her to be treated to have killed because she was suffering from postpartum psychosis is what period? What period?
I would put it to 3 months.
No, it is longer than 3 months. So if she kills a child within a period of, actually the position is 12 months, within 12 months, then she's not found guilty of murder. So what happens if she kills a child of a neighbor?
If she kills a child
Within that same period?
Within that, I think that one will be treated as murder.
No, tell us what you know. I don't want you to tell us what...
Because now that is a killing, another person who has life, and that is the other child has life, and it will not be treated in the same way.
But she's still suffering from postpartum psychosis.
Now that will depend now during the trial. If it is proved that maybe there was a mental aspect to it.
There is no mental aspect. She just gave birth to a child. And you have rightly told us that if she kills her child, then it is manslaughter, it is not murder. My question is, supposing she kills a child of a neighbor.
That would be murder, Commissioner.
Why? She's still like within the 12 months period.
Because they'll have to look at the other aspects, like, the elements of murder. We have other aspects to look at, whether there was malice aforethought and what have you.
So in the first case where it involves her child, are you saying there was no malice aforethought? Or are you saying there can never be malice aforethought when one kills their own child?
But there's that condition.
But the condition would also apply to a situation whereby she has also killed the child of a neighbor within the same period.
It is a tricky situation, Commissioner.
Okay. Anyway, finally, would this then be considered discriminatory because that advantage is not given to a male person who also goes on paternity leave, is a father of the child, he kills his child within 12 months of the child being born?
I would, thank you, Commissioner. I would not look at it that way because for the mother, postpartum is a condition, Commissioner, which affects the thinking of the mother. But for the father, there is no such condition, so it cannot be said that
all right.
it is
I think that's
discriminatory.
okay. I agree. Thank you.
Thank you, Commissioner.
Thank you, Chair. Good afternoon, Mheshimiwa.
Good afternoon, Commissioner.
Yes. Before I ask you what I want to ask, I think I want to visit your report from DISPOP. I don't know if you've been given a copy.
Yes, I was given a copy.
You've seen it?
Yes, I saw it.
And it's accurate?
Yeah, it's accurate.
So you've been taken to quite a bit of task to prove that you are a heavy lifter, given the report that you have. And I've had you struggling to explain what happens at the anti-corruption court and that it's a different ballgame. So that prompted me to look at your returns. Prior to that, I have your report here from engineer. When you're still at engineer, 2024. Maybe just before we go there, maybe we can hear from you. As a magistrate, how many judgments are you required to write per month?
A month, rulings and judgment, 30.
30?
Yes.
Are you sure about those figures?
At least where I was, we had to put that as our target.
It's your target?
Yes.
But ideally it should be 20. Yes. So I'm seeing here when you are an engineer, you are able to conclude rulings that concluded the case were 104 and judgments were 133. but there's a marked drop when now you come to Milimani Anti-Corruption, where you were taken to great lengths to explain why only one judgment. And you had mentioned that you had targets at Milimani Anti-Corruption. What was the target?
The targets at it's 4 judgments.
4 judgments in a year.
In a year.
So you've done 2 so far. We are halfway through the year, so you're on target. You can say that. Okay. Now, I just want you to briefly explain the peculiarities of the cases at Milimani Anti-Corruption, so that we are all on the same page. Why it is that while me at family, I'm expected to conclude more than 20, you're only expected to conclude 4. Or rather, more than 100, you're only expected to conclude 4.
Thank you, Commissioner. Even at anti-corruption court, even amongst ourselves, you may set the target yet, but it depends on the kind of case you get. During allocation, you may find that the case you get is a case which has, for example, there's a case with 18 accused persons. And with the 18 accused persons, you'll find like there are around 15 advocates. And with all that, corruption cases being what they are, you'll find that there are over 3,000 documents. So this case is allocated to Magistrate 1. Yeah? And then another case, you may find that another case, it's about, forging document. A forging document where you used a document to get employment. So you'll find that one only has around 3 witnesses. And around the documents may not be that bulky. So these are 2 judicial officers with 2 cases. So you'll find the judicial officer with the first case scenario that I've given, of course it'll take longer. He'll not finish as many cases as you, the other judicial officer with a forged document case will take. So there are all those matrices that we are also trying to navigate, so that you'll find that a judicial officer happens to get what I can call in quotes, forgive me for that, the bad cases. So you are struggling with those ones. Yeah? So you'll find that this judicial officer may not be able to meet the target in that financial year. But come the following financial year, you'll find now he has at least been able, maybe at that time he has finished this one with the 18 cases, and now he only has these other smaller cases. So you'll find that those are the complexities that we have in anti-corruption court. And when I came in, there were several of such. Unfortunately, when I came in, that is when we were now getting cases where there were stay in the Court of Appeal, in the High Court, and even Supreme Court. So you find that those were the cases that were now brought back to me, and unfortunately, I'm the one dealing with them.
Okay.
I'm the one dealing with them. So it's the complexity is with documentation, the number of witnesses involved, and the number of accused persons per file, and then the advocates involved in the cases.
So the DISPOP has taken into consideration all these peculiarities when they set for you the target of 4, while they set for me the target of 200.
Yes, precisely.
Now, another thing I want to ask you, I don't know if when did you go to anti-corruption?
I came to anti-corruption in September 2024. 2024.
I'm looking at your the court's performance report. I don't know if you know what their case clearance rate was for the year 24-25.
Maybe
before you went there.
Maybe if you can refresh my mind.
Okay, I don't have the report here, but I've been keeping very close tabs of that court, and I know it wasn't as impressive as it is now. I had hoped maybe you would know it, because I can see it has risen to 93. I think it was in the region of 40-something. It has risen to 93%. And I was about to ask you how you've been able to achieve this. I know you mentioned to us the time tracking card, which at least ensures that every minute spent on a matter is accounted for. What other interventions have you put in place?
Thank you, Commissioner. As I had mentioned before, of course, for the main cases, of course, I've explained, we have the applications, the ex parte orders and what have you, which also take a lot of time. So what we've done, unlike just leaving it open and giving them longer period, what we've told the ESCC, the investigators, is that you must be able to do, to complete all these investigations within 90 days. We are not going to give you any further extend those orders beyond that. So with that, they are able to close. They are able to close these files. In fact, that is a strategy we took. And then, of course, with the main hearings, we said, okay, we are not tolerating any adjournments.
Okay. Okay, I can see at least it's bearing fruit. How many judicial officers are in that station?
Currently, there are 4. We
There's
used
4
to
of
be
you.
5, but 1 was transferred.
So now the output expected of you should be 25%.
Yes, 25%.
I see from the report I have on you here, you are 2% shy. Maybe you can explain to us why.
Yes, maybe I would attribute that to, again, the complexities that I've just explained, where I came and inherited all these other files, the files that I'm now talking about. And then the other one, of course, it's maybe administrative duties here and there that at times keeps you away.
Okay. The report I'm looking at is for the period between July 2025 and December 2025. That's a period of 6 months when they were saying you did 23% out of the expected 25. July 25 to December 25.
Yes.
That is around the time you had reported there. When did you say you reported?
2024.
You reported in 2024.
Yes.
So you were the last one to report as at that date to that station?
Yes.
Okay. So the other question I wanted to ask, when you are carrying out case management, we are moving away from anti-corruption now.
Yes.
When you are carrying out case management in a civil case, what is your objective? What do you seek to achieve? And what kind of orders do you give?
When I'm carrying out case management, first, my main objective is to ensure that the matters are concluded as speedily as it is possible. And then secondly, that the hearings are done in a very smooth manner without any unnecessary applications as the case moves on. And also
So that essentially is to dispense with applications.
to dispense with
So that when you start
application.
the hearing, it's hearings throughout. That
Yes.
is one. What else do you seek to achieve?
And then, so that everybody knows what to expect as the matter progresses, so that there are no, a party does not ambush the other. Yes.
So the parties are made aware of each other's case, whatever documents they're presenting, and what,
Yes.
what else?
And also to help in clearing backlogs, if any.
Sorry?
To clear backlog,
No, I'm talking about when you are doing case management.
or that in that particular
and especially
file.
under Order 11. Maybe I should have specified, especially under Order 11. So you have dispensed with interlocutory applications.
Yes.
You are expediting. what
And
else?
also to avoid unnecessary adjournments.
Yes.
Yes.
Do you ever engage ADR?
Yeah, we also, yes, we also engage ADR in the sense that it is during that time that maybe the court can also encourage parties to attempt ADR.
Okay. And the orders you will give?
I'll
At the end of the exercise, what orders do you give?
I'll give directions in terms of how we'll proceed, in terms of the dates that have been given, and also if there are any orders of, for example, if or there's also the issue of admission of documents. That's the time you also find out whether there will be any objection to documents and what have you. The orders that I'll give is that the matter is ripe for hearing, and therefore it is set. We set dates. Yes.
Okay, thank you, and I wish you well.
Thank you, Commissioner.
Thank you, Chair. Good evening, Your Honor.
Good evening, Commissioner.
Do you need some water break? Are you okay? If you're okay, we can continue. If you need, you can just have it.
I think I would just continue. Let us continue.
Thank you. So I've gone through your sample writings. There are 5 of them, 4 judgments in criminal matters and 1 election petition. I was thinking you would have more than 1 non-criminal case for us to see your understanding of other areas. Yes, but you can explain to us when I ask you specific questions with regards to your sample writing. So the judgments are methodical with clear issue identification, logical reasoning, and proper application of law to the facts. Statutes and precedents are applied consistently. The evidence is critically assessed, and the decisions are coherent and well reasoned.
Thank you, Commissioner.
Yeah, so I commend you for that. In one of the decisions, that's the a criminal matter you handled in Engineer Republic versus Crispin Kamau Wahome. It was a case of robbery with violence where you acquitted the accused person, rightly so. I've gone through your analysis of the evidence and I do agree with you. But there is nowadays a little more need for sensitivity to victims. In your decision, you restate a decision of a high court, which I have no problem with, but in the context of sensitivity to victims of crimes. This is what you state while you proceed to find that the prosecution had not proven its case beyond reasonable doubt. So you quote a decision of the court, of a superior, the high court, and you say, an accused person is the most favorable child of the law, and every benefit of the doubt goes to him, regardless of the fact whether he has taken such a plea. It is painful for an innocent child of the law going to prison, and that is the reason behind giving an accused person the benefit of the doubt to avert such pain. I have no problem with you mentioning that particular quote from a superior court. But the victim in this particular case, you were silent on anything, or because you found there was no sufficient evidence?
Yes, thank you, Commissioner. Because at that point I'd already found that the accused was not guilty. At least the evidence up to that point showed that he was. And I was basically just requoting, a judgment of the court, which, I know I get your concern, because I know the victim, when the victim reads that, he'll be like, then what was my stake in all these hearing? So I get your concern, but unfortunately, it was a decision of a higher court, which I used to determine that case.
Okay, but I'm okay with your response. I thought you would go, because if you say you needed to put the concerns of the victims and you found that the prosecution had not proven its case, then it would be an otherwise funny decision. So abortion touches both. My second and last question is that when you look at abortion, it touches both on the right to life and right to health. So can a high court, in such a dispute before it, issue a structural interdict to give practical effect to these intersecting rights?
Thank you, Commissioner. I don't really see how the structural interdicts would come in, because for me, that provision is just clear. It talks if it's on grounds of health. I think the article itself is clear on it. So I would be reluctant to go the structural interdicts way.
So on an issue of right to health, can you issue a structural interdict?
Yeah, on issue of on the right to health, yeah, you can issue structural interdicts.
And right to life?
The right to life, that one is 50-50, eh?
Okay, thank you. Thank you, Honorable Chair.
Yes. I was reading your remarks, talking points actually, at the CSW, I believe. You said that you read the remarks of the DCJ, but you also had talking points on women in the judiciary in Africa. And you talked about women being 50% of the judiciary in Kenya, but you also said that there were some challenges that face women. Which challenges do you think are facing women in professional life, even in the judiciary?
Thank you, Judge Commissioner. I'm very passionate about that. There's a very practical example. All of us, okay, the women and the men in the judiciary, of course, we are all employed by the same employer, and you'll find that their reporting times are the same, and of course, living time is the same. But look at the woman, that is the lady, the female gender. We are supposed to report to work at 8. Do we stop to ask ourselves what the female employee has to do before she makes it to work at 8? She'll be the one to take care of the children. She'll be the one to ensure that the maid or the house help has prepared the children to go to school. She'll be the one at times, even the one to escort the children to to be picked by the bus. Yes, we've reported to work at the same time. But for the man, of course, the man will just shower and come to work. So we have both come to work, but the woman has done a lot more to enable her come to work. And yet she's not paid for that. But they have something to do with work. Because if she comes late, of course, she may lose her job or she'll be reprimanded. So that is one of the challenges.
Thank you. Yeah. Do you think sexual harassment is a challenge for women, not just in the judiciary, but in the workplace? And what do you think can be done?
Sexual harassment, of course, is a challenge. What can be done, of course, or what is the issue of course, enforcing the sexual harassment policy, and also trying to and taking reports that are made concerning sexual harassment seriously. Yes.
Okay. Because of time, let me just stop there. Thank you.
Thank you, Honorable Chair, and welcome again, Your Honor.
Thank you, Commissioner.
Now, you've spoken passionately about your stand on integrity.
Sorry, Commissioner, I needed some water. Can I?
Okay, please go
Thank
on.
you.
Please go on. You okay, or you want to sip more?
No, that is enough. Thank you, Commissioner.
Okay, thank you. Now, you spoke very passionately about your stand on integrity and the measures that you put in place, to just minimize the incidences of corruption in your court. My question is, how do your colleagues also describe you? Do you know what your colleagues say about you or the public say about you? Not in terms of integrity. How do you relate with your colleagues?
Oh, thank you, Commissioner. I relate with them very well. Yes, because I always meet them every other day, and I've never had them speak any ill or saying anything bad about me.
Okay.
Yes.
Very well. Yeah, from the feedback we have from the public and the stakeholders, there are no integrity issues that were raised against you, which is very commendable.
Thank you.
They also say that you are a very organized person, quiet, and you do not entertain visitors in your chambers. However, there are some few colleagues who are of the view that you mistreat those colleagues who outshine you in terms of the number of rulings or judgments or hard work.
Really? Commissioner, that is a surprise. Because in all the stations that I've worked and where I've been head, I've always been the one even encouraging them. Because, even as colleagues, sometimes we compete on the number of judges, and you'd find some heads of station would you take advantage of that by grabbing all the matters. But for me, I do not, and I encourage them, in fact, and I think all of them can bear witness to that. Yes, that is a surprise. Yes, thank you, Commissioner.
So you have no issue with those who outshine you?
I'm the head of station, so if they overperform, the station performs, so I'm happy as a head of station.
Okay.
So, yes.
Very well. Now, you've been at the anti-corruption court for how long now?
For slightly over 1 year.
Slightly over 1 year. There is this wealth declaration forms that you fill after every 2 years, judicial officers and the public officers. Could you tell us the rationale behind the wealth declaration, and just tell us whether it is meeting its intended purpose?
Thank you, Commissioner. The rationale behind the wealth declaration form is basically because it has something to do with unexplained wealth, because it is a way of tracking your wealth accumulation, so that if you over-accumulate, it will be very clear from that declaration, so that the EACC can then, make you try to, explain why that wealth has gone to the level it is. It is basically to explain your wealth in the course of your work.
Is it meeting its purpose?
It's not meeting its purpose, I would say that, and this is why. Because I would expect that the EACC would be hands-on in terms of looking at those declaration forms and then trying to really assess you. So there should be a way of a mechanism, a hands-on kind of mechanism to ensure that it is followed up by the EACC and other agencies concerned.
Okay.
Yeah.
Okay, I wish you all the best.
Thank you.
Chair. Oh, God, sorry.
Yes, just a follow-up question to what she's asking. There is the new Conflict of Interest Act, which actually gives the Commission the power to do what you're suggesting. But there are some people who are suggesting that it then gives the Commission powers to go on a fishing expedition, contrary to the provisions of privacy which are provided for under the Constitution. What is your take on that?
Thank you, Judge Commissioner. I would say that he does not infringe on the right to privacy, because in corruption matters, these are, there is the issue of public interest, and therefore I don't think it is wrong for the enforcing agency to try interrogate that form, because if there is a huge discrepancy, you have a duty to explain. Yeah, because they look at your income within that period. anything beyond that, and in a very excessive way, I think the EACC has the obligation to question you, to just seek your explanation to that, and which you should not be afraid of if the sources are legitimate. Thank you, Judge Commissioner.
Thank you, Honorable CJ. Mheshimiwa, I have a few questions for you. On this issue of corruption out here, it is said that judiciary is seen to be the weaker link in the fight against corruption. What is your take on that?
Yeah, thank you, Commissioner. I would say that that is debatable, but from where I sit, I do not think we are the weaker link, because we hear matters. As a court, we hear matters, so the matters have to come before us. And of course now we have to consider the evidence. So if the evidence meets the threshold, of course there will be a conviction. And you know, there is that hierarchy of courts. So I do not think, because we deal with the matters as they come, and we also consider the evidence that is brought before us. And so I would say, from where I sit, I would say that we are not, I cannot admit that we are the weaker link.
Okay. But why do you think that's the feel out here?
That's a feeling, maybe because, you know, there are many players in the justice chain, but unfortunately or fortunately, Kenyans just look at the court. They do not know that by the time this matter comes to court, there are many other players. There's this investigator, there's this reporting that is done, there's this flow. So they do not know if the investigations were not done properly. A Kenyan will just look at the verdict of the court and just say the court acquitted.
Okay.
Yes.
How has the use of technology impacted the work of a judge, both positively and negatively?
Thank you, Commissioner. Positively, I would say now it has, because now it has made work easier for judges in terms of, you know, the filings and what have you. You can just go to the system and get the documents and deal with them. And also in terms of transparency, it is also now transparent. And even as a judge, I like it when everything is transparent, so that I am not accused, you know, of doing funny things, because it is all in the CTS and in the system. And so, and it has also technology generally. And then there is also the issue. The issue where it has made work a bit tedious, maybe from my experience, from my personal experience, is the issue, let's say, of you know, uploading the judgment within 24 hours. Maybe that is a short period, so at times maybe that is the only part that I can say it as it is a bit problematic. But otherwise, generally, it has made the work of a judge much easier.
Okay. Finally, what do you do to debrief or to ensure that your mental health is stable at all times?
In most cases, I do a lot of exercises. I do some jogging. In fact, it is my habit. I do jogging. I do jog every morning and every evening.
Okay. All right. Thank you, and I wish you well.
Thank you, Commissioner.
Thank you very much, Commissioners. I think we have exhausted youth today.
It has been a hot.
So I will not have a second bite. I'll just give you the floor for you now to engage us.
On anything?
Yes.
Even capping the questions that were put to
whatever. We've been engaging you, so we always give a candidate an opportunity for the candidate also to engage us.
The closing submissions. Yes, I would maybe start by saying that I'm grateful to to the commission, the way you've conducted this interview. I think I'm impressed. Of course, Commissioner Judge, he has been very tough on me, but anyway, but that's it.
Just wanted to understand you. I'm meeting you for the first time.
But I like that kind of engagement, and I want to say that I'm not lazy. I'm not a lazy officer, and courtesy of you, Chief Justice. You know that I traveled all the way to New York to represent the women of Kenya, to represent you in that huge forum that is in the Commission on the Women's Status in Kenya. I was privileged to address several panels, and there's one thing that came out, and I always say, it is good to blow your trumpet, otherwise no one will. The commission, the Judicial Service Commission of Kenya, has a good name out there. And in fact, the issue of ensuring that this gap, the gender gap, is closed in the institution, that was something that everyone was just wondering how you've been able to do it. And it was observed that in all countries, we have the laws, we have the policies, but it is now the intentional nature, the purpose, and the individuals in those commissions that in those other commissions who have not been able to actualize it. But in Kenya, they have actually actualized it, and you have a very good name out there. And I would basically, and it shows here, even the way you've conducted this interview. Of course, in some questions I was off, but I was still handled in a very humane manner. You are living up to the spirit of our Constitution. So thank you once again.
You have attracted another one from Justice Chale.
Okay, you described how full the life of a magistrate is, the work that she has to do in the morning before she comes to the office, vis-a-vis the man who just takes a shower, goes to the breakfast table, and comes to work. Don't you think the men are failing?
Are failing?
Yes.
Yes, they are failing.
So if you are that man, how would you feel? You've left your wife to do all the work?
Judge Commissioner, maybe just while still on that, this was, it's a general observation. Otherwise, we still have responsible men who help in all those causes. But unfortunately, a majority of them, at 8, they come to work.
So if the men helped, the woman would not be overloaded. We agree.
And then there's also just that, female instinct. A woman would not even if I want to help her, the woman would still want that she
need to offer
want to be very close to the child.
Anyway, that's a conversation for another day. Thank you.
Thank you very much. Thank you, Honorable Barasa. We wish you well and encourage you to continue doing the right thing. I think you are a testament that if you do the right thing, there will be a reward for that. And that's why you were picked to represent the judiciary all the way to New York, because of that disability card that you innovated to help, vulnerable groups to access justice easily. And now even at Milimani, you have the logging card. You call it the logging card?
The time tracking card.
Time tracking card.
Yes.
We will ask the DISPOP to come here and demonstrate it to us how it works, because we are working towards case weighting, so that every case is weighted. This case which you did for 6 months or 1 year needs to be weighted and given proper weight.
Yeah.
It cannot be the same as any other case. You know, like maybe like Commissioner Rwanda said, a divorce matter, or you know, just a simple civil matter claim for damages, running down matter, or you know, even a simple contract matter. So we are working towards that, and we wish you well. Keep up the good work. We'll get in touch with you when we complete the process. It's very competitive, so we wish you all the best.
Thank you, Chief
That's
Justice.
why you are grilled, because it's not easy.
Yeah,
We have to get the best of every individual who comes here.
I agree, Chief Justice.
Yeah.
Thank you so much.
So you are released. You can go with your water and your writing pad.
Thank you.